Hello.
Hello, Prof.
Yes, sir.
Yes, sir.
It's still there, isn't it?
It's now better.
No, it's better.
Yes.
See.
Okay.
You cannot see.
So let's move on.
Okay.
As I mentioned, that the shadow director doesn't work in the company, or he probably works in the company, but not duly appointed as a director. That's
Okay.
the area you have to look at. He's not duly appointed. He probably works in the company, either with a higher level of experience or some level of influence that those that are appointed are accustomed to. It could be a person who has been on the seat on a different political terrain and handed over to another regime, and they believe that his efforts were positive and it's just a political changeover. That's why he's not part of the board. There are people you expect to be appointed, but due to one or two reasons, they were not appointed. So you have good reasons to consult somebody on an issue. There could be issues that the person was the chairperson of the committee. For some reasons, he was not allowed to come to the meeting to present. And he has details than others. So the shadow director's job may be one off for a particular issue that was to be discussed. But the court will take into account the kind of advice, the recommendations you made, how insistent you were in pushing the recommendation, and eventually, if the recommendation resulted to something detrimental to the company, then you will be roped in. But on the other hand, if you have been duly appointed, you have your own ideas, you have your own mind, and you must know that whoever appointed you saw something in you. That is one. But there are others who are also appointed because of representation. Yesterday, we mentioned that these days, Parliament tries to cure some level of arbitrariness, where 9-member board, government appoints everybody. So Parliament tries to say that one person representing this, two people coming from private sector, three persons in private business, one should be a woman, that kind of thing. That kind of thing. So it is still somebody's thinking in Parliament that, oh, for instance, I have been trying to understand why WAEC board, West Africa Examination Council, their board. There is a representative from Chamber of Commerce. And I try to understand that yes, Chamber of Commerce, they represent businesses. Therefore, WAEC, because in planning curriculum, the person the person on the board probably will talk in favor of business. But I am looking at the actual people who go on that board and the contribution they can make in that direction. So yes, the representations are there, but sometimes the person who is representing the constituency as suggested by Parliament in the Act. Sometimes it's terrible. Okay. So let's move fast. As I said yesterday, we discussed this. The de facto, any person not being duly appointed director of a company who holds himself out or knowingly, and knowingly is important, allows himself to be held out as a director of that company. As I sit here, if somebody says I'm a director of his company, I don't know. But when the person tells me that I'm going to apply for this and I'll make you a director of my company, and I know that you carry weight more than if I do it with my own name, then I know about it. And I've allowed myself to be held out by somebody as a director. So those are the things that we are talking about here. Okay. So accepting responsibility for the company's financial affairs. Here we are saying that the de facto director is not formally appointed, but carries out all the duties and makes decisions as a director. Sometimes he sits in the meeting. Sometimes he is representing the company somewhere and actually introducing himself as a director and so on. Now remember that Section 170 said those persons by whatever name called. So whatever name called means that you don't need the name director. But what it says is that who have been appointed to administer, to direct and administer the business of a company. So it is the role you play that makes you a director, not the name. And if you are playing those roles and you have not been duly appointed, then you are putting yourself in jeopardy. Acting as a sole signatory for the company's bank account, negotiating with third parties on behalf of the board, recruiting and appointing senior management to positions. These are mostly the board's, duties. And then sometimes you are asked to perform them and you are holding yourself out. It doesn't mean that if there is executive search, they are looking for a managing director, and you go and sit on a panel whilst other board members are there. No. But if you go to a meeting and tell them, yes, I represent the board. In fact, the board chairman should have been here. He's not here. And he didn't get any duly appointed board member. And you are representing the board or the board chairman. Then you are moving towards a de facto director. Okay. Executive director, we see them all the time. They work with us in the company. They are senior personnel in the company. And they are board members. So they are full-time employees and also a board member. When he goes to a board meeting, he wears his cap as a board member and talks like a board member. When he's at a management meeting, he is a director, of course, executive member of the company. And when you put the two together, he's an executive director. So director here as a board member executive as a member of management, and he is very powerful. Very powerful. So they work with the company in a senior capacity, usually concerned with policy matters or functional business areas of major strategic importance. Director of finance, or director this, director that, or chief so and so, chief operations officer, chief this, chief that, chief that. These days, the names are big, big, big. The value of executive directors to the board lies with their depth of knowledge of the business and with their technical business skills. So sometimes the setup of the organization is such that the chief operations officer is a technical person and very powerful. Everything depends on him. Things that happen in the night, things that happen during the day is the COO who is being called. If it's a marketing inclined organization, the head of marketing may be very, powerful because it is, let's say, a kind of job that marketing, they have taken, let's say, goods from some Indians, and their job is to market it. And their KPIs all about sales. In that case, the chief marketing officer is very powerful. And most people appoint such a person to be an executive director because at every meeting they want an update, and he's able to give an overview of whatever is going on and in different locations and so on. Sometimes the managing directors will be at a meeting, but technical questions they can't answer. Okay. The managing director is the leader of the executive team and responsible for the day-to-day management of the organization. He is someone who is responsible for the daily operations. As such, this individual is nearly always an executive director on the board. Nearly always means it is not compulsory. Some organizations. Now, let me add that the Act itself says that from time to time, the board would actually nominate one of their own. And that suggests that the board may appoint an existing director to be a managing director. And once that happens, you are a managing director because you are a board member. When you lose your position on the board, they will have to decide whether they want to keep you or not. But if you came from outside as a managing director, you are not a member of the board, but your managing director position made you a member of the board. Then when you lose your position as managing director, you are no longer part of the board. So let's go back. Is your mark around? And let's go back to read the sections in the company's code. The Act 992. Let's go back and start from Then section 180.
Prof,
Hello.
Prof, good morning.
Morning.
Please, I want to ask a question on the shadow directors. So I want to
Yeah.
find out if all shadow directors are former board chairperson or directors of the company.
No.
Immediate.
No.
Okay.
In fact, when there is a political changeover, for instance, let's give an example of the current, NDC government. The person appointed to GMPC would mostly ignore the Cgsl who was there for almost some number of years, who was an MPP appointee. They will mostly ignore him, go back to Alex Mood, who was there from 2009 to 2015, or go back to Chachu, who was there and exited in 2000. You will not consult any of the Kufuor guys. You will not consult any of the Akufo-Addo guys. So the immediacy may not be the issue. Because the immediate one, sometimes they're not even in talking terms. Sometimes those people who have handed over to others, some of them are not in talking terms because, for all you know, Randy Abe is not talking to Edubuahen because Edubuahen hears things Randy Abe will be saying, the kind of things he did, and so on. Sometimes he wants you to even be jailed. So it is very common that when people hand over to others and they take their handover notes and they rubbish it, or sometimes you have wasted your time to prepare 20-page handover notes over your 4-year, time. And the person goes about saying there was nothing in the handover notes. Oh, there was nothing in it. You see, so it is not compulsory that it should be the immediate person. They may never call him. Even when you want to call him, the former chairman was the chairman. Somebody wants to, let's consult the former chairman. He was working on something like that. Hey, no. What if they had anything good for this company, they would have done it in 8 years or 4 years. No. But they would prefer to call somebody who once upon a time was there, who has probably forgotten the architecture of the place. So it is not only. Sometimes, I don't want to trivialize things, but that shadow director can even be a pastor. Can be a pastor that the chairman or somebody believes in. That pastor has never worked in the company, but he sees prophecies. That's why they are consulting him. Some people call pastors and discuss issues of competition on the markets with them. Oh, my goods at the port, we can't get money to clear. And he's telling the pastor to pray that there is a breakthrough. Not that the pastor is going to give him money to clear. So the shadow director is any person of influence. And these people must believe in him. And the word says they are accustomed to the person. So it's not one of, contacts. but it must be a series of contacts and certain conclusions. Is anybody who has found that section 183? Section 183 of the Act. Yes, there's somebody put it on the platform.
So please, can I read?
Yeah, go ahead.
Section 180 talks about statutory directors.
No, talk about it. We'll go back to the substitute director. 183.
So 3 says 180.
183.
Okay, 180. Sorry. Executive directors.
Read from there.
Okay. Except as otherwise provided in the constitution of the company, a director may hold any other office or place of profit under the company other than the office of an auditor in conjunction with the office of director. The directors may from time to time appoint one or more of their body to any other office for the period and on the terms that the directors may determine and subject to the terms of an agreement entered into a particular case, may revoke the appointment. Please, can I continue?
Yes, so repeat that part.
The directors may from time to time appoint one or more of their body to any other office for the period.
So here, their body, the term their body it means that one of their members. So from time to time, they can appoint one of their members to work in the company as a full-time person. And I think that, I don't know whether it was last week or so, when I mentioned that when J.S. Addo retired, President Rawlings asked Dr. Agama, who was the board chair, to act as the governor of the Bank of Ghana. And that's how come Agama became mainstream person. And also played the dual role of governor and board chair. Okay, go on.
Subsection C, subject to compliance with section 185 and subject to section 214, that office may be remunerated by way of salary, commission, share of profits, participation in pension and retirement schemes, or partly in one way and partly in another, as the directors may determine.
Okay, so that's when they are taking the person to the full-time position, it will be guided by some level of incentives as they will determine. Okay. So go on to the managing director.
Managing director, except as otherwise provided in the constitution of the company, the directors may from time to time appoint one or more of their body to the office of a managing director. And section 183 to apply to that appointment.
Yes, so the discussion started from the executive director that they can appoint somebody from the board to be executive director. In most cases, it's the other way around. The person becomes a managing director and he has a slot on the board. Or the person becomes a management member and is appointed to the board. but the reverse also holds. The reverse is possible. So that is what we are talking about. That a board can decide that Kofi Mensah on the board should be acting as a managing director till we appoint a substantive managing director. And they can decide to confirm him. Whilst he is still a member of the board because he's probably representing an interest on the board. Now, when they appoint a substantive managing director, he comes back to the board as a board member. He doesn't lose his position as a board member. But if you came from outside to be a managing director or acting managing director and they are not able to confirm you, then you are likely to leave. You can't be on the board because it's an MD-ship that gives you the board membership. Okay. So that's, if there is any, have we finished with the 184?
No, please.
Okay.
The appointment of a managing director shall be automatically determined if the holder of the office ceases from a cause to be a director. And
Okay.
unless
So wait. If the person is serving as a managing director by virtue of his membership as a director, then when he finishes his term as a director, he cannot continue to be a managing director unless they so agree. Otherwise, you have been selected from the board to be a managing director. Now you are no longer a member of the board. Therefore, you have to go. Okay, go on.
it is necessary to give notice of meeting of directors or of a committee of directors to a director for the time being absent from the country.
Are you continue what you read?
Okay, for what I read, you've already said it. Unless the agreement entered. Okay, let me take it again. So,
Okay. Otherwise, go back to 180.
180. That is statutory directors.
Mm-hmm.
So, except as otherwise provided in the constitution of a company may appoint statutory directors in accordance with this section. A statutory director is one who is appointed to act as a deputy for another named director and as the statute in the absence of that director.
Mm-hmm. So, for instance, somebody like Sam Jonah. No, this is substitute director, yes. There's somebody like Sam Jonah on your board, a very busy person, but his name alone opens doors for your mining company. So you want to keep his name as a director, but the man is always traveling. So the board at a meeting can decide that for the purpose of quorum and other voting, let's appoint a substitute director who would represent Mr. Jonah when he is not, in meetings. This is coming from the board, and they choose to appoint somebody. It can be another smart mining executive. And then he attends meetings. He has the status of a director. He's appointed like a director, but he's made to believe that he is a substitute director. When the substantive person is there, he is still a substitute director. But they decide where you should sit because, one, quorum is a legal issue. 2, if there are 9 and that person becomes the 10th person as substitute director, the company pays all of them their sitting allowance. Now let's compare the 2 with, so the alternate director. Now read the 2 together. After reading substitute director, read alternate director, and then we discuss them together.
Alternate directors, except as
No,
otherwise.
have you finished the substitute?
No, please.
Okay, finish it.
So a substitute director shall not be counted as a director for the purposes of a provision in this act or the constitution of a company, prescribing a minimum or maximum number of directors other than a provision relating to a quorum. A substitute director is not entitled to vote at a meeting of directors or a committee of directors at which the director for whom the person is a substitute is present.
Yes,
Subject
that's
to-
why I said that if today Jonah is coming to meeting, then they'll show you that you sit on the back seat and as if you are in attendance. They allow you to sit in because as for Jonah, we've seen him today, we won't see him again till the end of the year. It means that you must follow proceedings so that your next meeting, you may be relevant in your discussion. So you can come to the meeting, but Jonah is there, so you can't vote. You can't be counted as part of the quorum and so on. But when he's not there, then you represent him. The difference between this and alternate is that the company chose the executive director, but the alternate director was chosen by Jonah himself. Jonah himself is traveling and he says, I'm bringing Kojopoku as my alternate director. And everything due me that you pay to me, pay to Kojopoku. And I have nominated him. He's not representing me, but he's sitting in for me in order not to create a gap in terms of quorum and voting and so on. The interesting thing about the alternate director is that you can choose an alternate director from the same directors. You can choose one of the directors to make him an alternate director, especially if your role or the board's information is sensitive. You don't want it to go out. You can decide to choose somebody from within. Now, if you tell him, we are going to discuss the appointment of deputy managing director, I am against it. So when it comes up for voting, vote against it in my name. Meanwhile, the person is for it. That's the director, he's for it. And you are telling him he should vote against it in your name. He has to do that. He has to do that. So he will have 2 votes, one for himself, one for the other person he is representing as alternate. Okay, so read the alternate directors.
Alternate directors, except as otherwise provided in the constitution of a company, a director may appoint another director or any other person approved by a resolution of the board of directors as an alternate director to act as a director in respect of a period not exceeding 6 months in which that director is absent from the Republic or unable for a reason to act as a director.
Okay.
That the appointment shall be in writing, signed by the appointer and appointee and lodged with the company. An alternate director so appointed is for the period of the appointment and for all the purposes, a director and officer of the company and not the agent of the appointer. He shall
Yes.
not be required to hold a share certificate, although under the constitution of the company, directors may be so required.
Mm-hmm.
He is not entitled to appoint an alternate director and shall not be counted as a director for the purpose of a provision of this act or the constitution of the company relating to a minimum or maximum number of directors other than a provision relating to a quorum.
Mm-hmm.
The company,
So here, what she's saying is that the the alternate director, there is a procedure for his appointment. You can't use your mouth to go and stand there and say that I'm going to Belgium. This in my absence, this person will be my alternate director. No. Look at the appointment procedure. It must be signed by the appointor and it must be countersigned by the appointee. And it must be lodged with the company. So always be sure that if we want to be relevant on the board, then the procedures of this nature, you know them. So when somebody says it's alternate director of somebody, then you're asking for the letter. You want to see the letter that came. The letter that came has been signed by one person. You can draw the attention that this is not the procedure of, an alternate director. And so go over that and let's go.
okay, so the appointment shall be in writing, signed by the appointor and appointee and lodged with the company. The alternate director so appointed is for the period of the appointment and for all purposes, a director and officer of the company and not the agent of the appointer.
Yes. So you don't go to meeting and go and play cards. Praising your appointor because he brought you to the board. You are an officer of the company. Use your mind. If there is a vote and you want to consult the person, you are allowed to consult the person. It becomes your shadow then. But it is not as if when anything that is being said, you are, oh, me, I'm here because of Mr. Jonah. So the other things are not important to me. No. You are representing the company and not representing Jonah. Okay. Go on.
He shall not be required to hold a share certification, although under the constitution of the company, directors may be so required.
Yeah, so some of the rural banks, for instance, for you to be a member, you have to hold a share. And when you are being appointed as alternate, that requirement shouldn't affect you. Go on.
He's not entitled to appoint another alternate director and shall not be counted as a director for the purpose of a provision in this act or a constitution of the company.
You have been appointed alternate director. Then you also come and you find yourself too busy and you want to appoint another alternate director. It doesn't work like that. So if you don't have time for the job, tell your appointer he would appoint somebody else. But you don't come and you want to appoint somebody. In the case of the alternate director, the salary or whatever that must go to Sam Jonah will not go to Sam Jonah, but to go to this new person. Sam Jonah can direct that all my entitlements give to him because he is, for the next 6 months, he is representing me. Sam Jonah can also say, pay my money to me and I will sort him out. Most of the time, people who do that, you pay my money to me, I'll sort him out. Most of the time, they don't sort them out. Most of the time, they end up cheating the people. And sometimes it brings a rift between them. Okay, go on.
The company is not liable to pay additional remuneration by reason of the appointment of an alternate director.
So
registered-
that's now you are just the company must look at your entitlements and give to him. But for substitute director, it's not like that. Go on.
The registered constitution of the company may provide that the alternate director shall be entitled to receive from the company during the period of the appointment the remuneration to which the appointor, but for the appointment would have been entitled, and the appointor shall not be entitled to remuneration for that period.
Okay.
In the
It says,
absence
go on.
in the absence of a provision in the registered constitution referred to in the paragraph B of subsection 5, the alternate director is not entitled to be remunerated otherwise than by the director appointing the alternate director. An
Yes.
alternate director who is personally a director shall have an additional vote for each director for whom the alternate director acts as alternate director at every meeting of the directors.
Okay. So that is also clear. Or you want to take it again?
Okay, I'll have it again. An alternate director who is personally a director shall have an additional vote for each director for whom the alternate director acts as alternate director at every meeting of the directors.
Okay, so let's say because our position, the information that comes to us are very, very, very sensitive. It's saying that an alternate director who is already a director of the company. So there are 9 directors. 3 are traveling, and 3 are putting one person as their alternate director. So he will be given 3 votes, including, and then add himself. That's what we mean. Okay, go on.
The appointment of an alternate director shall cease A. At the expiration of the period for which the appointment was made.
So in the letter that he sent, this alternate director represents me for the period of 5 months. When that 5 months comes, then his tenure is gone.
If the appointor gives written notice to that effect to the company.
The one who appointed you can also end your time in the organization.
If the appointor ceases for any reason to be a director, or if the alternate director resigns by notice in writing to the company.
Okay, so the person who appointed you, his term has ended. He's no longer a director, so you cannot continue because you are representing him. He's no longer a director, so why are you here? Or you can also decide that I'm not comfortable with this job, so this is my resignation. That is also allowed. Okay, go on.
And so the cessation of the appointment of an alternate director, both the appointor and the appointee are and may act as directors of the company, but an alternate director, unless personally a director, shall not attend or vote at a meeting of the directors or a committee of directors at which the appointor is present.
Yes. So when you remember that the alternate director was appointed by one person, otherwise they didn't know the person. But the substitute director was appointed by a section of the board. So the two of them, they are coming in. They differ. One is the company, one is individual bringing you. Okay.
So please, that's
Is
all.
that okay?
Yes, please.
So these are the provisions of alternate director. We'll talk about managing director. And then substitute director, alternate director. And we've said that alternate director. So when we say that a board member can appoint a board member, this is an example of a board member appointing a board member. One in his private capacity, one appoint the board member, the substitute director, in their capacity as a board. And he's representing the board by attending meetings when Sam Jonah is not around. But the alternate director was appointed by Sam Jonah himself, knowing very well that he won't be around. And if he doesn't appoint a substitute alternate director, then the company itself may appoint a substitute director who may not even know him. So he'll be better off appointing an alternate director that he can call from time to time to brief him what is going on in the organization. Okay.
Hello, Prof.
Yes.
Please, a quick question. This is John Mark.
Okay.
Please, is it the understanding that in the absence of a substantive director, the company so motu or by itself can appoint an alternate to that director, whereas the substantive does not want to appoint an alternate?
No. No. Unless I haven't seen, I mean, the act doesn't say that the alternate can be appointed by a second party.
Yes.
I mean, so the only job the company can do is to appoint a substitute. And they don't need the consent of the substantive one. They don't need his consent. But his alternate must still be approved. So, because the constitution of the company cannot override the act. So, granted that they have it in their constitution, that in the absence of anybody for a considerable number of days, they will appoint an alternate person. That is inconsistent with the act, which is superior to the company's constitution. So that is
And
not
they can
possible.
appoint a substitute.
They can appoint a substitute.
Okay.
They can appoint a substitute, yes. Okay.
Thanks.
So the roles, they are all directors that have been appointed. You can call them, look like an afterthought. But the substitute director, usually they appoint somebody who is beneficial to the board, such that even when the substantive comes and they are allowed to play some role, it is only the question of quorum that he will not be counted, he will not be seen, but he's appointed like a director, full sense of the word. He's written to, he responds as a director. Yes, so there are times that substitute directors have been roped in as full directors, at a later time, especially if your contributions are very, cogent and so on. Okay. So non-executive director is usually the name, sometimes you call them the NETs, non-executive directors. They are the typical directors we know of, not a worker in the company. So a non-executive director is a board member who is appointed to serve on a board, not necessarily a worker in that company. So when the government changes, then we see a lot of board appointments, and most of them are non-executive directors. They may have full-time jobs somewhere. They may occupy positions like being a chief, being a pastor, being a lawyer, being whatever. Some are also unemployed. I have seen 2 or 3 people who are, I won't say they are my friends, but they were their acquaintances in a way. When you give your, his complimentary card, the board membership is the only thing on the complimentary card. So, board member, so company. So apart from being a board member, he doesn't work. He has no job. Probably retired, probably not retired, but politically, he has been given a board membership. Okay. So there are the reasons why sometimes the board fees are paid. He is not working in the company. Ask him to come to the conference room for the meeting. You have to pay him a certain allowance, and you have to pay him the board fees if the company's regulations so directs. But the executive director will also take what he wants to take. Once this person is taking it, they will all take it, unless the company's constitution says otherwise. As I said yesterday, the details of the director's entitlements and all that would be addressed in the company's constitution. Okay. Now, within the
Prof.
yes.
Sorry, with respect. So will it make sense to say that an executive director who is an employee of the company and on salary to do the work for which he's been appointed? Now you are a board member, so to say, and the board role is deemed also as an extension of your work as an executive director. Would it be appropriate for the constitution of that company to say that you, the executive director, should not be entitled to board sitting allowances and board fees because that is your role as an executive director, as against non-executive directors who are from outside and come in to assist you do your work and go away?
No, in a sense that there is no appointment letter given to you as executive director of the company. The appointment letter would be to your management role, either chief finance officer, and your roles will be assigned as chief finance officer. In course of being the chief finance officer, if you are appointed a director, then you get a letter as a director, like any other director. The letter will not say you are executive director. It will say you are a director. But the fact that you have an appointment letter as a full-time employee plus the director letter, that makes you an executive director. So a letter may not be written as executive director, and for that matter, because the meetings are held in the premises where your office is, because the chairman chooses the location where the meeting must be held. A chairman can decide that let's go to Coconut Grove, Elmina. Let's go to this place. Let's go, so long as the company's finances can support. So the executive director gets everything other directors get. They get everything the other directors get. Maybe what would catch you is if the constitution of the company is very strict on directors filling the mileage from where they came to the meeting.
Kilometric
Then-
allowance.
You say?
Like kilometric allowances.
Yes, kilometric. Then the building that you are in, that's where you are coming from. You understand? Then
Yeah.
they will get you. But the meeting does not necessarily have to be, you may be on leave and you live at Sakumono, the meeting is held at Accra Central. The non-executive director may even be closer. So apart from that, where they have the flat rate for sitting allowance, that should take care of your commutation and then also your some level of inconveniences. Everybody takes the same, except the chairman, who may take something higher. Or the constitution of the company will say that these are the appointed, duly appointed members. If they are taking, let's say, 6,000 cedis, members in attendance will not get anything, because you assume that the members in attendance are like they are work in the company. They are necessarily invited to deal with one or two issues and go away. So they can decide that those in attendance will get half rate, or they'll get 1/3 rate, and so on. Or they will ignore those in attendance because they only came there to deal with one or two matters. So some organizations, the company secretary is also counted as the board. I mean, is entitled to everything the board gets, depending on who is the company secretary anyway, the weight of the person. Okay. So we'll quickly look at the independent director. The independent director is usually a non-executive director. Okay. It's usually a non-executive director, because you can't be an executive director and be independent. You work in the company, so your allegiance to the company is something that a reasonable person would defend. But the independent director is supposed to be a very objective director who is supposed to say things as they are without mincing words. And so an independent director is defined in detail as a person who is a non-executive director. It's not a representative of a shareholder who has the ability to control or significantly influence management or the board. So if somebody has 80% shares in the company and he brings you to represent him on the board, then they don't assume that you will be independent. Does not have a direct or indirect interest in the company, including any parent or subsidiary in a consolidated group with the company, which exceeds 5% of the group's total number of shares in issue. So this independent director should not be a shareholder of any of the company's subsidiaries, unless his shareholding is less than 5%. Once it's more than 5%, it will be deemed as a material interest, and you cannot be an independent director, or you cannot be considered or seen as independent director. Does not have a direct or indirect interest in the company, which is less than 5% of the group's total number of shares in issue, but is material to his or personal wealth. Now this is okay. So the previous one says that if the company like Zoom Lion, what is the company? Jospon Group. Jospon Group. Now, if you want to serve on the board of Jospon Group has about 60 subsidiaries. If you are a shareholder, let's say 15% shareholder of one of Jospon Group's companies, then we are saying that by virtue of the subsidiary that you have shares in, that exceeds 5%, you cannot be considered independent in that respect. And if the company is the only company not with subsidiary, you still have 5% of shares, then you are not considered as independent. Has not been employed by the company or the group of which it currently forms part of any executive capacity, or appointed as the designated auditor or partner in the group's external audit firm, or senior legal advisor for the preceding 3 financial years. So here you have not been a professional serving in that capacity in the last 3 years. It's not a member of the immediate family of an individual who is or has, during the preceding 3 financial years, been employed by the company or the group in an executive capacity. So the previous managing director was your cousin or your father and so on. When you speak and say, me, I'm an objective person, people will still link you to as if you are doing the bid of that person. So it is not a rank somebody wants to give you. Being an independent director has a lot to do with the weight they put on your advice, the way they put on your comments and so on at meetings or when there's crisis. So the assumption is that when the company's union is pushing for money to increase their salaries and so on, the assumption is that the executive director will not be objective, because the executive director has an interest in that money being pushed by the union. Therefore, no matter how objective he is, he cannot be seen fighting against something that he himself is going to be a beneficiary. Of course, there are people who fight against it, but it's in Ghana, for instance, when you fight against a union position at the board, everybody will hear. Everybody will hear. And when you are not a member of the board, you will see that you are treated like a traitor. You are the one betraying them. It's not, it's free from any business or other relationship, contractual or statutory, which could be seen by an objective outsider, usually called bystander, to interfere materially with the individual's capacity. Here we are talking about conflict of interest. You should not have any conflict of interest with the company that you want a contract from the company or something, even though you qualify to take it. Does not receive remuneration contingent upon the performance of the company. So some organizations, you are given a certain role and it is tied to the performance of the company. If the company does well, then you are paid higher. Let's say you manage their assets, and these assets, financial assets, if you're able to make 25% profit, then you will be paid this percentage. That is a performance-based payment. So the independent director does not receive remuneration contingent upon the performance of the company. So these are conditions that are very strict. And in Ghana, everybody is appointed onto a board, especially private sector, by somebody who is a friend, who is a family, who is related in a way. Nobody will appoint his enemy to the board. But what we are saying here is that he shouldn't be an immediate member, family member of an individual who is or has during the preceding 3 financial years been employed by the company or the group in an executive capacity. So when we talk of the employment of company in executive capacity, these are appointments made by the board. So they know that they have appointed that person or that person. But how to link the person to you is the problem. Otherwise, when you have a cousin that you are not so close, you didn't come to the office when he was the boss. Most people will not know. So the use of alternate independent director is sometimes some of the board committees, you prefer an independent director to chair because no matter how you look at it, you don't see him as having any interest in the position you want to appoint. Others have serious interests. So the independent director may be useful in some cases, and he is able to tell or speak his mind because he doesn't have to look left or right. All he's interested in is the company and the company's, interests. Okay. Another person who should be very invisible is the auditor. Now, when we appoint an auditor to a company, there is also a procedure. And he must qualify as a chartered accountant. So they also have an act, and that will tell you how you can appoint an auditor. But he should not be an officer of the company or an associated company, a partner of or in the employment of an officer of a company or of an associated company. So if, for instance, the company we are dealing with is a subsidiary of another company, then he shouldn't be an officer of that company when he knows that the Best Point Savings and Loans is a member of the Despite group of companies. And then you were an auditor of Best Point or an officer. You used to work as an executive of Best Point. Then you are coming to audit Peace FM. That kind of relationship we are not interested in. Because chances are that you already know what's Kwame Despite. So once you know him already, he probably is somebody you are looking for to teach a lesson. Or he's done something very unique for you and you're looking for opportunity to pay him handsomely. So you are not part of it. Not an infant, have not been found by a court of competent jurisdiction to be a person of unsound mind. And then a body corporate however, an incorporated partnership may be appointed as an auditor in name, and the appointment shall be deemed to be an appointment of the partners of the firm who, at the time of the appointment, are duly qualified. So, here, just like yesterday, we said a director may not be a body corporate, but a secretary can be a body corporate. In the same way, we are saying that the auditor can be in the name of the partnership of an audit firm, Asamoah and Yamoah, or so and so and so and so, or so and so and Williams. Yes, the name can be there, but it is assumed that there is a member of the partnership who is behind it. Okay.
Prof.
Hello.
Yeah, so please, does it mean that you can appoint a body corporate as an auditor?
You can appoint a body corporate not beyond partnership. You see that if it's a body corporate, I suspect if it is an incorporated body, the liability must be unlimited.
Yes, usually they are unlimited.
Yes.
The partnerships are unlimited.
Yes. So it is usually that the unlimited liability that is required. But if it's limited, I'm sure it won't be allowed.
So the KPMGs and the S and Youngs we hear, they are actually partnerships and not limited liability companies. Is that the
No,
understanding?
that's why they keep on adding to partners. You see, when they come to Ghana, KPMG Ghana becomes a local company.
Yes.
When they go to India, so, and in our partnership, what do you call it? Act 152, 1962, you are allowed between 2 and 20 people as partners.
Yes.
So you see that when they want to motivate people, they keep adding to the partnership. Yes.
Yeah.
So they would register as partner in Ghana. In fact, most professional bodies, architecture, so and so and so and so, and
Even
you
the
see
lawyers.
that, yes, most of it, partnerships. So the auditors they belong to chartered accountants, and chartered accountants, even those who are not auditing and they are actually assisting people to do the accounts and so on, they are all partnerships. Yes. So I think they took the cue from the lawyers who at the same time use the opportunity to avoid paying some taxes. Because if your liability is unlimited and there's no corporate veil, then it means that your liability towards tax or your tax obligations is a consolidated one.
Okay.
So if you work somewhere and you are paying tax, and then you also work in this partnership and you are paying tax, it gets to a ceiling that they think you've paid too much tax and it's okay. But if you are, an incorporated body, then strictly it's 30% of your profits.
Yeah.
which is very high.
Hmm.
25. It's not 25. A quarter of what you made throughout the year. Going to somewhere where you know that it will not be used for anything important. Very, very annoying.
Chop.
Mm-hmm. And the point is, if you allow, if you don't pay and you allow GRA to come and do tax audits, whatever you do, they will find something and then they will slap a penalty on you. And for the rest of your time, you will be paying by a payment plan, trying to deal with that situation. So sometimes it's good for you to walk in and declare that, yes, this year, this is how much I made. No matter how bad your account was. If they accept it, it's better. But if you don't go and they come and do the tax audit, even the things you bought on your mobile phone, your credit, everything, they will add it as part of the cost you should have. Because why should company buy credit on your phone? When your iPhone went for repairs, 3,000 cedis, it was paid by the company. Why? You say, I'm using my iPhone for but the phone handset has not been assigned to the company. You haven't registered it in the name of the company. So if you're using your own car, which is in your personal name, and now that's the car you are using for the work, you have to change the ownership to the name of the company. Otherwise, any expenses on the car, auditors will reject it. Because the Constitution doesn't say that you are entitled to car maintenance allowance. But they know that is the car you are using for all your rounds. But the car is registered in your name. So why should the company spend on you? But if you change your car name to the company's name as a company car, then it has no choice but to spend on its own car. Okay. Board meetings.
Please, I have a question.
Okay.
So a company, a group like Despite Group, can they
Mhm.
have one mother auditor, or they need to have separate auditors for each of their entities?
It depends on how they choose to do their accounts. You see, and that's why a conglomerate, that's a group of companies, usually engage in unrelated, activities or sectors, can decide to let each one be a standalone company, or once you form the group, then you want to present your accounts in a group form. Then you are presenting one account, usually called the final account, where all the other ones have brought in their accounts and consolidate the accounts. Usually it has some benefits because some of the companies don't do well, some do well, and eventually those that do not do well have nothing to report. So if you look at the Spice Group, maybe you two, Hereditary Salt, did not do well and there was no profit for the year. So if Peace FM was the only one that made profits, then the 30% is paid once, and the 25% is paid once on the one that made the profit. So they are better off doing the group submission, and they will have one auditor. They will have one auditor. But if you want to have different, for instance, if you're a holding company and a group of companies, they are very similar. Except that in a group of companies, the conglomerates, almost all of them, you have majority shareholding. All of them, you have majority shareholding. But 100% shareholding. But in a holding company, that company called holding has been established to look at the interests of a particular investor who has invested in various, companies. Some is majority, some is minority. So let's say he has 10% in, what do you call it? 10% shares in Republic Bank, 25% shares in, let's say, Car Bank, 80% shares in ADB. And then, let's say, Golden Beach Hotels, it has 15%. So it's a mixture. And he wants to have an office that coordinates all that. That is a holding company. So he's not majority shareholder in everything, but he has shares, and those shares are the subject matter of that holding office. And every year, the dividends that come out of, they are trying to, ensure that they get money to invest in other areas and make decisions where to invest and so on. So one accountant for a group is always available, the chief accountant for the group or group chief accountant. And for that matter, they can have one auditor. Okay.
Hello, sir.
Yes.
Mostly in organizations or in companies, they mostly have an external auditor and also as well as the internal auditor. And from what I understand from your earlier submission was that the auditor are mostly in partnership, in partnership with the company. So in this case, are you
No.
referring to, okay.
No. What we are talking about here is the external auditor, not the internal.
Oh, okay.
No, not the internal auditor.
Yes, that's what I got confused about now. That's what.
The internal auditor is a member of staff.
Okay.
He reports to the board. In fact, in most organizations, the internal auditor reports to the CEO, but his reports go straight to the board. But some of them, what are you hiding? Because the CEO is a member of the board, so he will see what you wrote about him. But what the auditor should be doing is to be prompting the CEO. He should be writing, reports to prompt the CEO and help him to prepare the books better. Help the CEO and the chief accountant to prepare the books better for external auditors. But some of them are wicked. They would not do that. They would rather be trying to expose you in a way. Oh, these people, they don't listen to advice. Oh, they want to do what they want to do. And then they would set you up in a way, something that technically you didn't understand. You realize that when the external auditors come, then you are, on the spot. They are actually lambasting you. But all the experience of external auditors, they know that the internal auditor should have prompted them on this. Sometimes they blast them. So the internal auditors and the external auditors too, they are not cool at all. Because when you come and you say, who approved this one? He said, the CEO. The auditor also ratify the payment. He said, yes. The internal auditor ratified. Then they also have a report and say that the internal auditor is not professional enough. So the external auditors are very powerful because they deal directly with the board. And all the things that went on, your answers to queries that they found, some of them you were discharged because you brought the right documentation and so on. And for external auditors, they are interested in approvals and procedures. Who approved this? The CEO. CEO has no power to approve. This amount should have been approved by the board. Then that is a loophole. Anything more than 100,000, send it to the board. And this is 150,000. And you are trying to justify why CEO approved and you paid. So there are a lot of conditionalities that the internal auditor could also be of help or be advising. But sometimes they think they must be treated the same way as the chief accountant. So if you're not treating him as the chief accountant, it means the chief accountant knows everything. Let him do it. And he always wants the external auditors to find the chief accountant incompetent. In the process, the company suffers. Okay. So the appointment of the auditor is done in a way that you appoint them, I think they work for some number of years, and then you have to go back to the board and appoint them again. And if your constitution says they can only come twice, then when they finish their term, you have to bring a new one on board. That is the distribution of wealth. Otherwise, one person will take all the money for years. This time you have to roll them over. Let me see. It says, okay. So he also has, the auditor also has the qualification that we discussed for when we're discussing directors. It shouldn't be somebody convicted and then undischarged bankrupt, culpable of a criminal offense, whether convicted or not. This one is whether convicted or not will not be there. Seems to be debarred. Yes, debarred by the competent authority from being a member. So a court of law or the ICA, Institute of Chartered Accountants, or whatever, they have revoked his license. Once that has been done, he will not be qualified as an auditor. Okay. So board meetings, the chairman convenes board meetings through the secretary. But any director can requisition a meeting of directors through a company secretary. For some reasons, many people do not do that. Many people don't do that. Unless the chairman is very stubborn. He doesn't listen to anybody. He will be running around. All of a sudden, we want a meeting. So occasionally, some people would force a meeting, especially AGM. Most people don't want any AGM for them to be held accountable. Directors may meet at least twice a year, one for financial and the other for operational issues. The minimum that is required by the Act is twice a year. But we all know that twice a year meeting for a company is not adequate. So best practices, most boards will meet once in a quarter. Once in a quarter. But the legal one, the requirement is twice in a year. And it is also a requirement that at least the financials must be looked at as one of the meetings, and then you have to report on that. Because the company is supposed to file returns to the office of the registrar. So if you don't work on finances in any of your meetings, what kind of returns are you going to file? Quorum is an important aspect of directors meeting, a quorum. But even AGM, if you don't meet the quorum, automatically the meeting is adjourned to the following week, same time. So quorum is an important aspect of meetings. Directors may not transact meetings beyond 4 weeks if their number reduces below the quorum, unless the meeting is to fill the vacancy. You cannot be pushing, and you keep saying that, oh, we didn't have the quorum. We didn't have the quorum. As I said, automatically it shifts to the following week. And if at a point, the following week you get a quorum, you start a meeting. If you don't get a quorum, it shifts automatically. And there's a caveat that it cannot be continuously shifting. Meeting decisions that are determined by ordinary resolutions. When there is a tie, the chairman may have a first or second vote. This would all depend on what you have in your constitution. If the constitution says the chairman should have a casting vote, if the constitution says there should be a second chance of voting, whatever it says, it's up to the constitution of the company. That's why these days people are registering companies, and at first, oh, the number of directors must be an odd number. It must be an odd number, either 5, 7, or 9. If your constitution says the chairman has a casting vote, there is no problem. There's no problem. You can have 8, you can have 6, you can have, because once there is a tie, there is a solution to the tie. So if it's 10 and 5, there is a tie. The chairman has a casting vote. That will break the tie. Okay. So, meeting times. What's the meeting? Okay. Okay. No proxy votes allowed in directors' meetings. The only the way you can use proxy is the alternate director that you can appoint. But if you don't attend meeting, you can't ask somebody or call this person to say that he should vote for me. No. Do the right thing. Have an alternate director and ensure that he votes in line with what you want to vote for. Directors may delegate powers to committees consisting of a member or members. So we will talk about some committees. The board will have standing committees and ad hoc committees. If an ad hoc committee, let's say somebody complains of rape in the company, so it goes beyond ordinary sexual harassment that probably has a code and has been dealt with. This is rape, and it took place in the company. You want an ad hoc committee, or if you have a discipline committee, to be the one to investigate that. And then present it to the executive who will forward it to the board. That ad hoc committee, when they finish their work, we call them functus officio. Once you finish your work, you are no longer needed. And that committee is disbanded. But standing committees, they don't get disbanded. So standing committee, anytime there's a problem, you go to them. Okay. So they have standing committees, they have ad hoc committees. The ad hoc committee is like a task force that works to solve a particular or give a particular direction. And the standing committees are where you stay on for long and until they are changed. So the term standing committee refers to any committee that is permanent in nature within the management structure of the organization. Okay. So we'll look at some of them. The audit committee is obviously chaired by a person with financial background or finance background on the board. Sometimes it's difficult to get one, but the person must have a background in that. Now they should have oversight of internal controls, approval of financial statements, and other significant documents prior to agreement by the full board. It serves as a liaison with external auditors, high-level compliance matters. So you have internal controls in the organization is weak. It is the audit committee who should know better and then try to, close the gaps. The audit will send them the reports for them to look at before it goes to the main group. Reporting to the shareholders. This audit committee is supposed to bring the information that will be used at the AGM, annual general meeting. So some organizations, so long as the audit committee has okayed it, then that is fine. If it doesn't cross audit committee, it goes back to other auditors or finance office for them to work on it. Sometimes the committee may carry out investigation and may deal with matters reported by whistleblowers. The audit committee also plays a key role in ensuring the board of directors is accountable to the company's stakeholders. Okay, so there is a remuneration and compensation committee. Most organizations, almost every year, it becomes repetition, salaries. Our structure has been affected. Then you need to have a committee that is going to deal with those things, especially executive salaries. What are their entitlements? What should be paid them? What should not be paid them? Why are they complaining that their salaries are low? And so on. So the remuneration committee will deal with that. This committee decides on the remuneration of executive directors and sometimes other senior executives. It is responsible for formulating a written remuneration policy that should have the aim of attracting and retaining appropriate talents and for deciding the forms that remuneration should take. This committee should also be made up entirely of independent, non-executive directors, consistent with the principle that executives should not be in a position to decide their own remuneration. So that is the committee for remuneration. Nomination or corporate governance committee. Some of these ones, some companies have, some companies don't have. A nomination committee will evaluate the board of directors of its respective firm and examine the qualification, skills, and characteristics needed in the board room. Their duties extend to board succession planning. It is for them to find replacements. These people have finished their term. They will soon be going by December. Who are we bringing on board to replace them? They think about that. Nomination committee are the board's voice on governance, and they get to make the decisions about how they want to shape the company's governance policies. Risk management is another area that many companies delegate to their audit or nomination teams. Risk committee, it is not every company that has it, but this assess the risk appetite of a company, and then they try to offer some solutions to the looming risk. Meeting times. Your regulation should state the frequency of meetings. And as we said, board meetings are usually held quarterly. But depending on the exigencies or the emergencies of the situation, the chairman can call any meeting at any time. I know a company that was holding board meetings every month. Every month, they hold board meeting. And it is clear that it is the board sitting allowance that they are interested in. That's one. Because you can't have too many things piled up that every month you have to meet. But the rural banks, they have a different approach. The directors are closer, more day to day than ordinary board. Because it is the directors who are running the company. Okay. So your constitution should state some of these meetings and so on. It's not something an act should say. Now, before the meeting, the secretary would have to look through your constitution to look at the minimum days that you give the people notice. So notice to the meeting, you should also comply. So at that stage, the company secretary is very busy. until the meeting comes on, is very busy calling the people to come. Quorum. The regulations will dictate the number of members that constitute the quorum. No business can occur unless there is a quorum. If too many members fail to attend, the board may not reach a quorum. Okay. When board members fail to attend meetings, decisions may be made without their expertise, for which they were appointed, and that defeats the purpose of having a diverse board. Some regulations require board members to attend at least 2 regular or special meetings. Now, all this must be in your company's constitution, how to go about the meetings. Okay. Board members that fail to comply with 2 meeting rule may be asked to resign. Now, this is a typical meeting agenda. Call to order, approve meeting. Some chairmen are very democratic. Before the meeting, they ask the secretary to go around if members will add to the agenda things that are of importance to them. Okay. Board meetings should have some etiquette. Etiquette, that's a politeness that you need to deal with in your company. Good timekeeping is essential for the meeting to start and run as it should. Refrain from interrupting other members as they speak. Do not try and chat with other members secretly. When a meeting is going on, then you are testing another person, commenting on what is supposed to be done. You should not attempt to undermine other members with body language. Looks, this is very common with a woman. Okay.
It's true.
Prepare fully by reading and digesting the board papers. Sometimes, before the meeting, they will bring a lot of papers, things you have to read because they are going to discuss it, to be discussing it. Come up with relevant questions or solutions to problems. Ensure you know what you will be voting on and have a clear understanding. Remain focused on your agenda. Any deviation from the set plan for the meeting can cause an overrun. Declare conflicts of interest or potential conflicts as they come up in conversation. Treat everyone with respect, even if you disagree with their points. Accept that the full board is responsible for the board's resolutions, even the members who voted against them. So these are some of the do's and don'ts of board meetings. Then we have annual general meeting that talks about the minutes of the previous meeting, usually about a year ago. Financial statements of the company, ratification of directors, election. These are annual general meetings to deliberate on the business progress and shareholders are interested in this meeting. When the AGM doesn't go the full length, you are not able to get everything you are looking for. You couldn't conclude on matters. Then you can also call for an AGM to finish those issues. So we'll bring it to an end here. It's 10 o'clock. I have another class at 10:30. And as I mentioned, you need to put yourselves in groups of 7. An assignment you're going to do, I'm going to send the assignment to you this week. And then you are supposed to do assignments. It's a video assignment you have to do. So you read the write-up and then you act accordingly. You are going to act in the videos. And the videos will come to me. Okay. So this is where we'll end. And it's been nice. The Accra people, I still don't know them face to face, but I'm sure there will be an opportunity to see them. Any question? Otherwise,
Yeah, Prof.
yes.
Before you sign off, please, I was hoping to, I'm not sure if I missed it, on secretary, company secretaries. In the instance where, did you discuss it, please?
Company secretary, it's on the slide. But
Okay.
because this time it is, there is a qualification for a secretary. We talked about that.
Yes.
Yes. So we didn't go into detail because a secretary is typically not a director.
Yes.
But a director who acts as a secretary will still be expected to behave as a director.
Okay. So in terms of the remuneration of that secretary of that director who acts as secretary, what happens?
Most of the organizations, especially banks and so on, the secretary is a full-time employee.
Yes.
So he is like an executive director, sort of. He takes his salary here and he takes his... If the secretary is a body corporate, you have already agreed on what charges you would. In fact, I have been on a board where the secretary was a legal firm, a law firm, and they broke down their charges on the covering of the minutes alone. Then if there is, I think the covering of the minutes and then preparation towards a meeting. Yes. Sometimes they have to deliver hard copy, let's say documentation to members. And they charge, per the kilometric, and then, yes. And they do all that, and then there was a line if they have to represent the company on litigation.
Yes.
Yes. So that was the first time I attended the meeting, and I asked whether they act as retainers as well. And they were not. The company had no retainers. So it makes sense that they, in a way, were suggesting that they are available either to be retained, or if you don't have retainers and you have issues, it will always be an emergency issue. So we would be able to stand in that direction.
Okay. Okay.
So they broke down what they were going to charge and all that. But different companies have different ways of treating their charges, especially the involvement of the company itself. For instance, if you are a legal firm that acts as a secretary, one of the questions is, if the chairman says, secretary, give us condition of service documents. We don't have condition of service. We want you to design condition of service for us. If it was a person secretary, she was going to form a team and do it.
Yeah.
And with the salary she earns, it will be treated as an internal matter, or at best, honorarium. But you can't do that to a body corporate. You can't ask a body corporate to go and, design a condition of service documents and
you
say
not
that.
pay.
No, because
you have to pay.
it's not part of their secretarial job.
Okay.
Yes, so you have to, look at how you want to deal with the company that you are representing.
Okay. I asked because I find myself in such a role and the other side is not seeking to understand. So I wanted to know whether there's a statutory provision which I've not met yet, regarding that kind of.
No, the statute is very, silent on even when it's a body corporate, it is assumed that it doesn't work or it's not a member of that company. So it's external. And once it's external, then you have to deal with it as a professional body and what its rules are.
Okay.
And I would suggest that, yes, it goes with the way the auditors are employed. Because I was part of a company when the accountant left for the US and everything got messed up. He went unceremoniously. And so there was a gap in the accounting. And when the external auditors came, we asked the external auditors to make good the accounting year because it was only up to May or so. The rest of the year, before we appointed a new accountant, a lot of things are not being entered the way they should have been entered. They charge specifically for cleaning the books.
Yeah.
So I think that is the approach you need to use. There is a different charge for being a secretary. And if you want to do it per hour base, if you want to do it per meeting base, and so on, that is, so for a meeting preparation, I would say 2 days in distribution of minutes, electronic, if the company prefers electronic. If they want files to be sent, you charge all that and then give them a bill.
Okay.
Okay.
Prof, I have a,
Thank you.
Okay.
yeah, Prof, my question is, if you have a retainer as a company and you want to form a board, is it
Retainer in what? Retainer in what?
A lawyer who is a retainer?
Okay.
Yeah. Is it advisable that you will include such a retainer as your board, as a director?
The retainer is usually a company.
Yes, please.
Now you want to take
please.
somebody from there to serve on the board?
No, the same company.
I don't get it. Let's say
So the retainer.
So, Prof,
Bensiential.
if I may ask, I have a. Yeah. So let's say they've gone for, you have a lawyer who serves as your company secretary.
Yes.
A single person lawyer, a sole lawyer practitioner, so company secretary. Now, your company is now growing, so you want to regularize the arrangement, and you want to say that, okay, I want you to be on my board as a director.
Okay.
But the role the guy is playing already as how do you call it?
A solicitor and barrister.
A solicitor and advisor. He's already on a retainer basis with you, not on ad hoc basis.
Yes.
It's on retainer basis. So let's say every quarter something goes to you for the advice he gives you. But now that you are reconstituting your board, you want him on board as a member, as a director. So maybe he comes in there as both a director and a secretary.
There are two different roles.
Exactly.
Two different roles. But I will separate the two. I mean, if
please,
okay, so when the board is sealed, what will you do?
Okay. It's in line with what John Mark is saying. My question, he has really put it well for me.
Because if the board is sealed, that board member cannot represent himself.
That's true.
Yes. So in some cases, if it is only soliciting advice, I mean, that is okay. That is okay. He can be on the board. And then you decide that when there's a litigation, you have somebody you follow.
An external lawyer, yeah.
Yes. Yes. Because he can also sue the company.
Of course, yeah.
Yes. So maybe because of some fees you have not paid or accumulated and so on, he can sue the company. So sometimes you have to avoid the duality and be able to, because when he has to sue the company, he has a lot of information. So it's not against the rules, but you also have to, I mean, minimize your vulnerability.
Okay.
Hello, sir.
Yes.
Please, I have a question.
Okay.
Okay, sir, please, is there any provision guiding how a founder of a company can withdraw a board chair if he's not acting in the best interest of the company?
Can withdraw a board chair?
Yes, is there any provision guiding how a founder of a company can withdraw a board chair if he's not acting in the best interest of the company?
You can't, because you see, these things depends on the way your company is registered.
Okay.
You understand?
Yes, sir.
How is the company registered?
Okay, let's say it's a limited liability company.
Yes, private.
Yes, private.
If it's a public company, you can't do that. Because a public company, they don't care about who is the founder and whatever. It is about shareholding.
Okay.
Now, if it is registered as a private company, are there other shareholders? What is the shareholding structure? Because you need that board chairman to be somebody who knows what he's about. For instance, the board chairman can call for, you see, you can only pull him out during an AGM.
Okay.
Now, that AGM, the board chairman is the one chairing.
Okay.
And he decides whether to use a pool system or ordinary resolution to take decisions. So when he sits down, he says, today decisions will be taken by the pool system. That's when he has your back, you the shareholder. He is on your side. He will tell the members, decision will be taken by the pool system. And that's what they are going to use to work. Now, if it's a pool system, the voting goes per your shareholding structure. So if you have 60% and 10 others have 40%, when he votes one, it's 60%. The others' votes will be according to their shareholders. So all of them gang up against this person. They will get 40 against 60. It won't work.
Okay.
But if the board chair is not on your side, he will say that decisions will be simple majority or ordinary resolution. And one person, one vote. Your shareholding doesn't count. And therefore will carry the day. So the best way to pull out a board chairman is to find means of dissolving the board. When you dissolve the board and reform it without him, then that is okay. But if you tackle him alone and he gets the consensus of the board, it will be difficult for you to succeed.
Okay. Okay. Thank you, sir.
And
Thank
Prof, is it not also because at that level the board chair may be as a director?
Is that the board chair may be what?
Maybe a director. For which reason
No,
the mover must go through the process.
That's why, but he is a board chair. He is going to, unless you're talking about a shareholder who is a director. But the board chair who is a director, if he doesn't call for meeting, how do you even deal with the situation?
There's no
So
meeting.
you end up in court.
Yeah.
It's a
And you
critical
want to avoid,
situation.
yes. You want to avoid going to court because as a shareholder, you don't also want to be seen as a litigant. Next time you're looking for people to serve on your board, it becomes difficult. So it is something that you really have to, use diplomacy.
All right. It's true.
Mm-hmm.
Thank you.
Okay. But mostly, a Ghanaian shareholder, especially a majority shareholder, who is a director, who want to chair the board. Who want to chair the board.
Yeah.
Mm-hmm. Even the founders, you see that we have a lot of executive chairmen around. He is the managing director. He is also chairing the board.
Prof, I think that is where we have a lot of problems in our corporations or companies.
Yes, because if it's executive chairman,
and they want to always veto.
Yes. If it's executive chairman, he can collapse the board at any time. When you think you are helping him to achieve something in his company, in some cases, he's not even paying you anything. But the fact that he can't have his way. I remember there was a case where the guy was bringing his second wife as deputy managing director. The company doesn't have the slot for deputy managing director. And he was trying to create deputy managing director. And for all intents and purposes, he has found a new lady. He said the first wife is not too educated. He's found a new lady and he wants the lady to be deputy managing director. And obviously, the board was not happy. The board was not happy. And the fact that the reason why the board was not happy was that one of the members knew the wife very well and thought that he wouldn't be on that board while the wife, because if you bring a second wife as deputy managing director, the interest of the first wife will be extinguished. To be extinguished. And they thought that at that time, the man was not thinking well.
What is that problem?
He was in love. He was. You see, so eventually, the first wife, had to, she got wind of it. And it became a family issue that the man's grown elderly children all came into the issue. And eventually the woman was warned severally, the second wife, and she had to abandon the relationship. So there are a lot of issues that I also, I don't know whether it was this class that I told that I was a consultant for a company where every day the deputy managing director and the driver and accountant, they were stealing 7,000 Ghana cedis every day. 7,000 Ghana
It was
cedis.
this class. It seems yesterday or so.
Yes. And then the person happens to be, the deputy manager happens to be the wife of the chief executive. So she was stealing from her own company every day. So some of these issues, when the family issues come in and you are a lawyer and you want to advise the man, at that time, the person you're advising sees you as an enemy. He sees you as an enemy. I found a lady and I have promised her that I'll make a deputy managing director. I'll let her sign check. I'll let her sign checks. I'll let her do this. I'll let her do every travel. She will go. And you see that the guy is behaving that way because either he's under a spell or he's, excessively in love, or when everything, clears from his eyes, he'll be blaming you. Why didn't you prompt me? So, John, in your case, what will you do?
Well, it's a critical one. Well, I think I will advise that we reconstitute the board.
But you see, at that stage, the man's focus, anything that will prevent the woman from becoming deputy managing director, he's not interested.
Yeah.
Prof, I think at that stage we should try and convince him to resign so that he will stay home.
The man doesn't reason. He's not reasoning.
Some of us are going through the same thing. So
you see, the reason why he wants the woman closer is the ability to travel with her on company tickets. You ask him to go and stay at home. So sometimes some of these issues, you realize that the company is doing well, all of a sudden.
Until the woman came.
Something, yes. Yes. So the lawyer was trying to say that keep the woman in another business or give her any money you want to give her. But bringing her to be part of this business, eventually she'll claim it.
Yeah.
She'll claim it. And the man didn't understand that, no, she can't claim it because everybody knows when he started business and blah, 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 blah. And she can't claim it. She's not even that type of woman. She was speaking for the woman.
The spell is working.
So sometimes the best way, the best way for, you see, the women, when they are first wives, they see good reason why this shouldn't happen. When they are the second wife, when they are the one enjoying it, then they don't see anything wrong with it.
But by that time, they are transactional wives.
Yes. So many of our issues in the local is also about polygamy and things. Many of the time that businesses have not been able to go through the second generation. When people, die, their businesses collapse. It's also because of polygamy. Because at that stage, if you are not able to bring your children together because they are from different mothers, the moment you die, the mothers are now, they see that every child is legitimate. So every mother is standing behind the child and fighting for the child. Because as for the woman, she knows that once she was not married or once she has been divorced, she doesn't have authority on the inheritance. But the child is the child of the man, that's all. And every woman is pushing, advising their children, hey, don't do this, don't do, and putting poison in the case, who used to even be very, close. That becomes a problem. And eventually you realize the organization is no longer formidable. Among fighting not as if anybody work with the man. Maybe one is a doctor, one is a pharmacist, one is an accountant. They don't even have the time to come and run the company. And they also see the outsiders the father was working with, they see them as opportunists. Now they are trying to get them out of the company. They don't know any customer, they don't know any supplier, they don't know what keep the company growing. Then it collapses. Once we have a lot of examples, local transport company collapsed just like that. At that time, he was the richest man in Kumasi. If, not the whole of the northern sector. That's how. Dennis, is that an old hand or new hand? There's a hand up.
Yeah, Doc. So mine has got to do with since probably there's I believe we are going to meet you again before exams.
I am contemplating. I'm discussing with the head of departments. You may not write exam. You may work on the videos as the final one, because this is a practical. This is a practicum. Okay. But 1 or 2 of the years we've written exam in addition to that because their attendance wasn't encouraging, and the HOD said we should conduct exams. So I'm sure by next weekend is supposed to be the mid-semester, isn't it?
Yes, please.
Yes, by next weekend, I'll firm it with him and then I'll let you know.
Okay, so by what you are saying, if we are able to do the video very well, as expected of us, we may not write exams, right?
No.
Okay, all right. Class, thank you very much.
The case study will be sent to you. Once I am able to deal with that way, okay, then I'll let you have the case study because
we'll put in our all and do it very well for you, sir.
Yes. Okay. So all the best. I need to join the other class now.
Thank you very much, Prof.
Thank you very much, Prof.
Okay.
Yeah, thank you.
Take care.
Thank you, sir. Today I've not heard of him.
I didn't call Fidelia because I saw her reading, so okay.
Thank you very much, sir. We'll call you.
Okay, sir. Nice day.
Accra, please join the link. Let's look at our work final, please.
Okay. Share the link again. Share it. Share the link.
Okay.
Thank you.
If you're not sharing the link, you're not doing well.